On June 2, 2025, Malcolm Talley found himself at the center of a legal dispute after an encounter with officers Jacob Ellis and Jacob Stearns of the Detroit Police Department. Police initially arrested Talley on a felony charge of felonious assault. During the encounter, he informed officers that he was employed as a security guard and legally possessed a valid Michigan Concealed Pistol License (CPL), authorizing him to carry a firearm. Under Michigan Compiled Law 750-82, a felonious assault charge requires proof that the accused intentionally placed another person in fear with a dangerous weapon without intending to commit murder or cause serious bodily injury. Although the original felony case was later dismissed, prosecutors filed a new allegation claiming Talley had been carrying a concealed firearm while under the influence of alcohol. That charge was eventually reduced to a civil infraction under MCL 28-425K, which applies when a CPL holder has a bodily alcohol content of 0.2% or higher while carrying a concealed pistol. According to the prosecution, officers believed they saw a rifle equipped with a mounted light sweep across their patrol vehicle. They argued that this observation provided sufficient probable cause to approach Talley, secure the firearm, and place him under arrest. The defense strongly disagreed, filing a motion to suppress the evidence on the grounds that it was obtained through an unconstitutional arrest and therefore
At what point was my client under arrest?
I would say once the handcuffs were put on, he's not free to go, sir.
Okay, so he was arrested on the scene prior to be placed in the police van, correct? And what was he placed under arrest for?
FAPO.
Okay, felonious assault on a PO. Any other charges he was arrested for at that point?
At that time, no, sir.
Was he ever under arrest for brandishing a firearm?
No, sir.
Was he under arrest for being under the influence, being 0.08 or more blood alcohol content while being in possession of a firearm?
He did not go over 0.08, so no, sir.
Okay, so he wasn't under arrest for that, correct?
No, sir.
Okay.
He does an additional charge, sir.
Okay, fair enough. So fair to say that the only charge that he was placed under arrest for at that scene was for felonious assault on a police officer, correct?
My initial charge, yes, sir. But the additional charge would be carrying concealed while under the influence, yes, sir.
Okay, so that was the additional charge, correct? The carrying concealed under the influence?
Last week, yes, sir.
Okay, and are you stating that that was a misdemeanor, or are you stating that's just the civil infraction?
Well, again, with our system, it prints off as a misdemeanor, sir. So that's why we had a ratio ticket as a civil infraction, sir.
Okay. When he was placed in the van and then transported to the Detroit Detention Center, you also believed he was under arrest for having a bodily alcohol content of 0.08 or more while possessing a firearm?
No, sir. I said he was arrested for FAPO, an additional charge of carrying while concealed.
Okay, understand. So I'm crystal clear. The only charge you arrested him for was FA, or felonious assault on a police officer, correct?
Yes, sir.
Also known as, in Michigan, assault with a dangerous weapon under 750.82, correct?
No, sir.
Okay, fair enough. Okay. I believe he stated that you and your partner were in a scout car, correct?
We were in a work MPO, sir.
A van, okay. And you were the driver?
Yes, sir.
Okay. And you initiated a conversation with my client, is that correct?
Yes, sir.
Did you initiate with anybody else?
There was two others at the window.
Okay. Did my client tell you he had a CPL?
He never disclosed that, sir.
Oh, he never said he had a
No,
CPL?
someone else later on in the investigation did say he has a CPL.
Okay.
He actually refused to identify himself.
Yeah, okay. And you asked his identity after you arrested him, is that correct?
Once we detained him.
Okay. I believe he stated he's not answering any questions, is that correct?
I don't recall that, honestly.
Fair enough. Okay. And fair enough to say that, let me back up. Let's go through the incident. So after you and your partner get out of the car, you continue conversation with my client, is that correct?
Correct.
And then I believe you stated even two commanders showed up, Sergeant Honeycutt as well as two lieutenants.
Mm-hmm.
Is that yes?
Yes, sir.
Okay. And you discussed the incident with them, is that right?
Yes, sir.
And one of them actually said, that's FAPO, he's good to go, something of that nature, correct?
I believe so, sir.
Now, at that point, did my client retrieve the rifle out of a vehicle?
Yes, sir.
And he was directed by an officer to do that, is that correct?
I do not know that, no, sir.
Fair enough. Because you were talking to command officers, probably.
What's that, sir?
Because you were talking to command
Correct,
officers.
sir. I was
Okay, fair enough.
What's going on?
Okay, that makes sense. You had Sergeant Robinson come to the scene, is that correct? Or Sergeant Robinson of the traffic unit came to the scene
With the PBT.
with the PBT, and that's a preliminary breath test, correct?
Correct, sir.
And Sergeant Robinson had asked my client to take a test, the PBT test, correct?
I wasn't there, sir. I can't testify.
Okay, fair enough, fair enough. Were you ever made Actually, fair enough. I'll leave. You weren't there. Fair enough. Now, my client is placed in handcuffs and then in the back of a transport van, correct?
Yes, sir.
And it's at that point that you were asking for his ID and his wallet, correct?
Either that or just before, sir.
Okay. But didn't you and the other officers have to let him out of the van to retrieve his wallet from his pocket?
He said he had it in his hand, sir.
In his hand, that's correct. He also had a knife on him, is that right?
No, he had the mace on.
Mace, that's right, mace. And that was on him when he was placed in that vehicle, correct?
Correct.
Now, you did the pat down to find a firearm on my client prior to that, correct?
Right.
You didn't find the mace?
I thought it was a lighter, sir.
Oh, I thought it was light. Okay, fair enough. And the wallet you just left on him for that time?
So I didn't feel the wallet.
Okay, fair enough. Is the Detroit Police Department policy to remove all weapons from a person prior to placing them in a transport van?
Yes, sir.
Also, remove all lighters, is that correct?
Yes, sir.
And that just, it was busy, that wasn't done, correct? Correct. Okay. Actually, when you address the odor of intoxicants or alcohol, did you state to the charge not to rack things up, but he smells of alcohol?
Yes.
Okay. So that goes to support it was a secondary inquiry.
Well, yeah, my first part of our investigation was if there was a potential threat to make sure that threat was removed. Officer safety, number one. Okay. So.
Okay, fair enough. Didn't you state? Well, actually, I'm gonna bring you back into when you're in the police van with your partner and you first pull up to speak to my client. During that discussion, didn't you tell him we didn't think it was intentional in reference to pointing the firearm, correct?
True.
Is that yes?
Yes.
And just so I'm clear, on the property that was taken from my client, there was a bullet-resistant vest, is that right?
Bulletproof vest he did have on.
Okay.
It was never removed at the location.
Okay, fair enough. But the Detroit Police Department took custody of that?
Yes.
And they took custody of the rifle, is that right?
I personally got the rifle, pistol, the radio, the
Okay.
CPL license.
Okay, so there was a pistol, a rifle, CPL license, and
His handheld radio.
his handheld radio. Okay, all right, fair enough.
Those
Just
were all
one
placed
moment.
on evidence.
I'm sorry.
I said that was all placed on evidence.
Okay, fair enough.
Violated Mr. Talley's constitutional protections. Defense attorney Dennis White argued that the original felonious assault arrest was legally defective because the essential element of criminal intent was completely missing. An evidentiary hearing was later conducted in the 36th District Court in Detroit, Michigan, before Judge Ramsey Heath. During the hearing, the prosecution called Officer Jacob Stearns as its first witness to explain the events leading to the arrest and establish the sequence of what occurred. After Assistant Prosecutor Tamika Horn completed her direct examination, defense attorney Dennis White began his cross-examination, focusing on the legality of the officer's actions and the factual basis for the arrest. Defense attorney Dennis White opened his cross-examination by scrutinizing the officer's handling of the arrest and questioning whether established police procedures had been properly followed. His first line of questioning focused on Officer Stearns' search of Mr. Talley before transport. White pointed out that departmental policy requires officers to remove every potential weapon or hazardous item from a detainee before placing them inside a police transport vehicle. During his testimony, Officer Stearns acknowledged that he had mistakenly identified a canister of pepper spray as a lighter, allowing it to remain in Mr. Talley's possession instead of immediately confiscating it. The defense argued that this oversight was inconsistent with standard Detroit Police Department safety procedures, which require officers to thoroughly search a suspect and secure all weapons before
Officer, I noticed at one point my client retrieves a rifle out of the backseat of the SUV. Is that correct?
Correct.
Did you direct him to do that?
I asked him to.
Okay. Is it common police protocol to tell a potential suspect who pointed a gun at a police officer to go ahead and retrieve that firearm and give it to me?
Not usually.
Okay. So you felt comfortable enough that he wasn't a threat, like he was going to try to shoot you or anything, correct?
I didn't want to escalate the situation.
Okay, fair enough. Fair enough. But if you're telling somebody to obtain a firearm, you do not believe that at that point, that he's a threat to you, correct?
I'm sure.
Okay. So normally if somebody, if there's a firearm, that say a Detroit police officer comes across in the middle of an incident, say a fight, a domestic, we'll say domestic, and they say there's a firearm over there in that dresser drawer, would you tell that person to get the firearm or would you go over and get it?
I would ask them.
You would ask them to put their hands on the firearm and then give it to you.
Your Honor, objection, this line of questioning is not exactly what's going on here. That's an example, speculation of what the officer would do in another type of situation.
Fair enough. Fair enough. I can move on. He answered. I can move on. I made my point, I think. Now, throughout your investigation, did you come to know that Mr. Talley was working security at one of those establishments?
Yes. Let's go over this data.
Okay. So he was actually working security that evening, from your understanding?
I'm not sure.
Okay. But you did receive information that he was working security, correct?
That he was employed there.
Employed, okay, correct. Now I noticed that you registered, or you wrote down the serial number to this rifle. Did you subsequently run that through the law enforcement information network?
I did.
And did that rifle come back registered to my client?
It did.
It's fair to say that my client was placed under arrest when he was placed in handcuffs.
I didn't place him in handcuffs.
I understand that. What I asked is, when he was placed in handcuffs, was he under arrest?
I would assume he'd been detained at the time.
Well, you're assuming that, but what I'm asking, you're the police officer.
So, Judge,
You're on
Your
the
Honor, he's asking an assumable question. This officer did not place him under handcuffs. He was on a separate detail at that time, so he would not have personal
Let me build
knowledge.
foundation. You know, I'll back up.
Thank you.
Build up.
Okay.
Did you see my client placed in handcuffs?
No.
Okay. Were you the arresting officer, or was your partner technically?
My partner.
Now, when you asked my client for his date of birth, do you remember that testimony where the prosecutor asked you if that was lawful or not? Is that correct?
Correct.
You agree with me, though, that when you asked that question, my client was already under arrest, correct?
He was detained.
Okay. So he wasn't under arrest?
Like I said, I'm not sure at that time.
Okay. Who detained him then?
My partner.
Okay. So you'd rely on whatever your partner stated was the time of arrest would be the time of arrest?
Yes.
Okay, fair enough. And fair enough to say that when you asked for that date of birth, that my client was already in handcuffs.
Yes.
When this interaction started, you were the passenger in the police van, is that right?
Correct.
And you noticed the light and the firearm and then went to speak to my client, correct?
Correct.
And you stayed seated in the car?
I did.
And that interaction lasted at least 2 minutes, correct?
I'm not sure.
So for an officer, if you feel under threat, you want to get on your feet. You want to get out of the car, correct?
I would assume so.
Okay. And that's fine. In this case, though, you didn't feel that threat where you want to get out of the car to make sure you're on your feet when you first spoke to Mr. Taylor, right?
Correct.
We can rewind the video if we need to, but I'm just trying to speed it up. While you were sitting in the car, did you or your partner even say to my client, look, we don't think it was intentional what you did. You just act like an idiot, so to speak.
I don't recall.
Okay, you don't. Fair enough. As your partner was the arresting officer, you agree he decided the charges and what to move forward with. Is that correct?
Yes.
And of course, that was in consultation with a lieutenant and 2 sergeants, correct?
Transportation. Mr. White then shifted the discussion back to the original felonious assault allegation. He reminded the court that Michigan compiled Law 750-82 requires proof that a defendant intentionally placed another person in reasonable fear of an immediate assault. According to the defense, that essential element was missing. White emphasized that Officer Stearns had previously admitted that officers never believed Mr. Talley intentionally pointed the firearm at them. If law enforcement itself concluded the incident was accidental, the defense argued, the felony assault allegation lacked the legal foundation necessary to support an arrest. The cross-examination then turned to the officer's investigation into possible alcohol consumption. White questioned the legal basis for pursuing an additional firearm-related offense after officers detected the odor of alcohol. Under Michigan law, the consequences depend entirely on a person's bodily alcohol content. A BAC between 0.2% and 0.7% is treated as a civil infraction for a CPL holder, while a BAC of 0.8% or greater may result in criminal misdemeanor charges. Officer Stearns testified that Mr. Talley's preliminary breath test remained.
Let's just look at what we heard in this hearing. We heard Mr. Talley, assuming everything's true, that the prosecutors presented, all the witnesses are completely true. Let's take it all at their word, exactly at their word. We still win. First, basically they're saying Mr. Talley was pointing a firearm, he's being an idiot, basically. It was not good, it wasn't the safest thing to do. And I get that, I understand that. But what's very clear in this whole case is, was there probable cause to make an arrest? Let's look at things. First, the 2 officers are in a car, they pull up to these subjects. They don't get out of the car, they don't get on their feet. They sit there for, well, he doesn't even recall how long. They have a conversation on their tushies or on their butt, basically, in a car. If officers under threat that they're going to get shot at, they're getting on their feet. Now, of course, I'm not an expert in this by any means, but in my 15 years, you get on your feet. They did not feel threatened by Mr. Talley at that point. They were just trying to have a discussion. What made them upset was when my client gets argumentative That makes them mad. And I get that. I watched the video. I was an officer. That teed me off too, right? I'm just trying to like make a point and move on and be done with it. That's what they were doing. And I'm not faulting them for that. But that doesn't make it a crime. When it becomes a crime is when they're upset and say, hey, look, they're not getting my point. I get where they're at with that. I do. Then they say, we're going to look at this a little bit further. Pull the van over, they get out, then they start having a discussion with Mr. Talley. What does Officer Ellis do? He actually has my client retrieve the firearm from an SUV. So if an officer feels under threat, they're not going to say, hey, go put your hands on that firearm, sir, and then go ahead and hand it to me. They're going to retrieve that firearm themselves. I found it interesting, though, that the officer testified before the objection came out and I moved on. He said if it was a domestic situation and the gun was in a dresser drawer, he would probably ask them to go get it. Okay, fair enough. That's him. I understand that. You are not feeling threatened by any means. Okay, so that's the facts we have. Later on, there's a PBT. It was pulling some teeth for the officers to admit when my client was under arrest. They seemed to be very afraid and skittish around that issue. Both of them. When was he under arrest? We're trying to work around this because their case is weak. There is no probable cause. Now, let's look at that. The second one, Officer Ellis testified. He relied on his partner's decision. He was the primary officer. He's the arresting officer. It's his decision. Fair enough. I understand that completely. But let's look at what we have. We have the first statement within a minute of this incident, and from that chair, the officer in charge admits, we didn't think it was intentional or anything. He says it, he states that he stated on that date, and he confirms it under oath, which I get. They didn't feel threatened. Totally understand that. But then I go over every possible charge they could have arrested him on. What charge did you arrest him on? Felonious assault against a police officer. Fair enough, felonious assault. So let's take that. We know that felonious assault under 750.82 requires a dangerous weapon and an assault. What is required for any assault in Michigan is common case in law, intent. The officer said on the video and confirmed under oath, we didn't think you intended to do it or anything. There goes their case. Gone. It's over. I went through every other charge they tried to post hoc come up with. Well, he's intoxicated. Well, we didn't have the PBT at that point. Well, this and that. Nothing to show a PBT shows a point of weight, which is what's required to make intoxication while in possession of a firearm. To make that charge, you need 0.08 or more. They said, well, we think he's under the influence, which I get. They smelled alcohol and he comes back with something. And then later at the station, there's something. But no, there's no testimony. It's a 0.08. So let's take that charge. That's what the ticket was written for originally. That's gone now. We know that. That's gone. That was a defect. It doesn't even, the government had to dismiss that or amend, which we had no problem with, amend it to a civil infraction because they have to admit there's no probable cause on that. Let's go to the third one. What was mentioned today. Let's also look at what was mentioned in the people's response. It says, well, they had probable cause because it's brandishing a firearm. Okay, just because you have probable cause of one thing, you could have it for something else, which I get. But brandishing a firearm in Michigan, was it required? Intent. And actually, let's see. I'm just going to quote from the jury instruction. Brandishing a firearm. Michigan Criminal Jury Instruction 11.25a. Defendant is charged with the crime of brandishing a firearm. To prove this charge, the prosecutor must prove the following. First, defendant possessed a firearm or had control of a firearm. And of course, it defines a firearm as a weapon that will shoot out a projectile by explosive action, is designed to shoot out a projectile by explosive action, or can readily be converted to shoot out of a projectile by explosive action. Okay, cool enough, fair enough. Possessed, they got it. Cool, I'll give them that. Probable cause, they got it. Second, that while possessing or controlling the firearm, the defendant was in a public place. Give it to him. We're sitting here learned, right? Not a problem. That's on public. Third, while possessing or controlling the firearm in a public place, the defendant deliberately pointed it, waved it about, or displayed it in a threatening manner. Okay, I don't think we can even say it's threatening given their testimony, but it's okay, Judge. We can actually give them that one too. Let's go to the last one, though. Fourth, that when the defendant pointed, waved about, or displayed the firearm, he did so intending to cause another person or persons to be fearful. Intent is required. What is the statement from the grand arresting officer? We don't think there was intent or anything, and he confirmed it under oath. We went through every possible charge that they could have had for probable cause to make an arrest. I even nailed it down several different ways and said that was the only charge was felonious assault, correct? Yes. There's no disputing that. There is no probable cause to arrest my client. Would there be cause potentially to write him a citation on the alcohol thing? Yes, but that's not for arrest. So I'm asking this court to rule that there was no probable cause to arrest my client. Therefore, anything that was taken fruits of that unlawful arrest, such as an intoxilizer 9000 at a station, would certainly be suppressed. That is governmental action. Now, of course, as an officer of the court, that's a civil infraction, so the rules get a little bit looser for civil infraction with respect to the exclusionary rule, but this is considered quasi-enforcement. This isn't code enforcement, so your grass is too long and I took a picture in the backyard when I trespassed. This is an arrest where he's deprived of his freedom, not only that night, until the next day. And so, Judge, we believe that any evidence of intoxilizer 9000 would be suppressed too, but first and foremost, there's no probable cause. And so we would ask that this court make that finding. I think it's not even close call in this situation. Thank you, Judge.
I will allow rebuttal if you have any. Do you have any other statement you wish to make to the court? Ms. Warren?
In closing for the people, I believe there is probable cause here. He was suspected of being under the influence of alcohol during this investigation. He was in possession of a firearm, and I believe that is the probable cause necessary to prove this ticket on the civil infraction that he was under the influence. He smelled of alcohol. He did test his alcohol at PBT at that time for 0.06, I believe, and at the DDC. Now, what's going on at the DDC is not necessary at this hearing today, but for purposes of this civil infraction, he was above a 0.02, Your Honor, under the influence. And not only did he have the rifle that he allegedly pointed at the officers, he also had another gun or firearm that he had failed to disclose to the officers altogether until a pat down. This community deserves better, Your Honor.
Anything further, Mr. White?
It does deserve better. It deserves a better investigation and deserves better enforcement. I don't fault these officers one bit. I did that job. I don't fault these guys. They're trying to be safe. I get it. They're under tough circumstances, but it still doesn't rise to the level of probable cause in the situation. It just isn't there. If we want to talk about the reason for an arrest could be under the influence, there's nothing in this record to say there's a 0.08 on a PBT or otherwise. And even later, we're not even at that point. So there just isn't probable cause here. I'm not attributing ill will towards these officers and that they were trying to do anything evil by any means. I think they were trying to educate Mr. Talley. That didn't go so well, and so they made their point in other ways. Fault them. Right. But that doesn't rise to the level of probable cause.
Right. Thank you.
Below the criminal threshold. As a result, the original criminal allegation for carrying a concealed weapon while under the influence could not stand and was later reclassified as a civil infraction. The prosecution then called Officer Jacob Ellis to testify. Once the prosecutor completed her questioning, Dennis White began another detailed cross-examination aimed at testing the credibility of the officer's version of events. During his questioning, White challenged the claim that officers genuinely believed they were facing an immediate deadly threat. He pointed out that Officer Ellis remained seated inside the police van during the initial encounter. Conduct the defense argued was inconsistent with how trained officers normally respond to an active or life-threatening situation. The defense also discussed the collective knowledge doctrine, which allows courts to evaluate probable cause based. The prosecution's explanation for escalating the encounter depended largely on the combined observations and shared understanding of the officers involved rather than the independent judgment of a single officer. The defense then addressed the legal concept of a de facto arrest, arguing that once a suspect—
There's a reason that we have a probable cause standard. And that standard is that it must be based upon a reasonable suspicion that a particular crime has occurred or is about to occur. Here, it's obvious that the particular crime that was being alleged was the use of the firearm, a felonious assault, the use of a firearm on in the felonious assault of a police officer. I will say I find the officers to be credible in this case. As I watched, although it's not part of the record, both attorneys and the court have watched Officer Stern's body cam video, as well as now Officer Ellis's. What occurred to me in watching that video was that given the number of officers that converged on the scene, it became almost like a game of telephone, where the first person to encounter says one thing and that starts to balloon out to something else. What seemed to be communicated by Officer Stearns, who was one of the first on the scene, certainly. It's not as clear to me from Officer Ellis, but that the firearm was being handled in some way. And in the handling of that firearm, sounds like from the testimony today that the light was initially pointed at feet, came up and around as it was being placed back in the vehicle where Mr. Talley had to retrieve it from. That's borne out in the officers' statements that they did not believe the aiming of the firearm at them to be intentional. However, on the scene, things started to change because now the allegation is going through various officers and it starts to kind of take on a life of its own. And Mr. Talley then ends up in handcuffs, arrested on suspicion of felonious assault on a police officer, pointing a gun at them, even though both of the officers first on the scene said that they did not believe there to be an intentional aiming. But he ends up in handcuffs, not free to go, as Officer Stearns testified, in a van, and what this court finds to have been under arrest. Officer Stearns said that he would have considered it to be under arrest because he was not free to go. And Officer Ellis said, well, whatever Officer Stearns says. If he says that's when it occurred, that's when it occurred. So clearly here, the arrest was for the felonious assault on a police officer. I know that there were some other cases running along with this. The court has had trouble, quite frankly, making sense of them because the register of actions contain all kinds of different weird dates about the date of offense. But what we did pull was that it would appear, although it contains a different date of offense, I don't know why, that there was initially a charge for fingerprinting refusal as to Mr. Talley. Don't know if that was the same case. Okay. But that one was dismissed for compliance. I then had another case where Mr. Talley was charged with, looks like an assault and battery, found not guilty by a jury. Again, I can't make sense of the offense date in that file. And then I have another case from 2025 where I can't even tell exactly what the disposition is here. The latest thing I can see is an October 29th entry there of 2025, and then nothing further, no final disposition. I'm sorry. I am looking at an October 27th date in 2025 where there's an order of dismissal. So, I don't know if any of those others are riding along with this one, given some of the allegations that were made. But given what I think is the officer's, quite frankly, very credible testimony, I do not believe that either of the officers perceived a threat to them at this time. An intentional threat. Again, borne out by the statements, borne out by asking Mr. Talley to retrieve his own firearm and hand it to the police, and perhaps this is what would happen under the same circumstances. I don't know. As a layperson, familiar with the law at least, but not an officer, certainly I'm not going to ask a person who I feel is a threat to me to go and grab a firearm. I mean, that's just a logic. So at this time, I do find that there was no probable cause for the arrest for felonious assault on a police officer.
Is placed in handcuffs, the law generally treats that individual as being under arrest. Mr. White maintained that because the encounter began without any immediate threat or hostile behavior, officers skipped the stage of a brief investigative detention and instead carried out a full custodial arrest without first establishing probable cause. After Officer Jacob Ellis completed his testimony and was excused from the witness stand, the court turned its attention to defense counsel Dennis White's legal arguments. Mr. White urged the court to suppress all evidence collected during the incident, arguing that it flowed directly from an unlawful arrest. He relied on the exclusionary rule, a constitutional doctrine that prevents prosecutors from using evidence obtained through illegal searches, unlawful seizures, or arrests made without sufficient legal justification. The defense also invoked the well-established fruit of the poisonous tree doctrine. Under this principle, when the initial police action violates
Captain Cameron, where are you currently employed?
Detroit Police Department.
And how long have you been with the Detroit Police?
25 years.
And at this time, are you considered like the custodian of forfeited firearms?
I'm the commanding officer of the property unit, yes.
Okay, and what does that entail that you do?
It's one of several units that I am in command of. There's also a lieutenant, 2 sergeants over property.
And in this matter, were you able to, take possession from evidence at the Detroit Police Department, Mr. Talley's property?
Yes, ma'am.
Do you recall what items are included in the evidence? And if you need something for refreshment, I do have that.
There's a long rifle, 2 magazines, a CPL permit, a handgun. Those are the items on evidence.
And was there any other additional items that weren't on evidence that you have in your possession today?
Bulletproof vest.
You heard the court's order.
I did.
And is there a process that Mr. Talley has to take, including in addition to the court order? May I present the court order to you?
Yes, ma'am.
Okay. May I approach, Your Honor? The people are presenting a court order dated February 5th, 2026 that has been held in abeyance as a reason until today's hearing. And at this time, I believe the order is going to be enforced by the court.
Correct. And for clarification, there was a period of time when the order was not held in abeyance. However, given the city's request to respond to the motion, I then pulled it back. I believe it was February the 13th, and held it in abeyance until we could resolve the matter.
Thank you, Your Honor.
Mhm.
And Captain Cameron, for the record, have you had an opportunity to review the order that we've been discussing?
Yes.
And as a result of that, is it your understanding that the city has to comply with the order?
Yes, ma'am.
And is there a process that needs to be taken outside of the written order enforced by the court today for Mr. Talley to retrieve his items?
The court order needs to be presented to the precinct of occurrence, which in this case will be the 3rd precinct. The supervisor will then review the order, complete a task in our tracker system, have it approved by the captain or commander of the command, which is 3rd precinct. Then that information, with that information, a task number will be provided to the offender, the owner, to the owner, and he would take that information to the property unit at 1301 3rd Street, provide the task number to the property officers, who would then return the property to him or her.
Okay. And at this time, to begin that process, will he present in person for that to the 3rd precinct?
Yes, ma'am.
All right, thank you, Captain Cameron. I don't have any further questions at this time. I'm not sure if the court does or.
I want to make sure for process, when the order is presented, because we'll get it today, we want to get it presented as soon as possible. When we present that to, I believe he stated the commanding officer at the 3rd precinct, and then has to go through some channels, how long does that take?
It could take 24 hours.
Okay, we're talking in days, not months, right?
Correct.
Okay.
But the property room is only open Monday through Friday, 7 a.m. to 1 p.m.
Okay, and then he would have to go to 3rd Street to the headquarters to that with the task number to get retrieved.
Correct.
Okay, I appreciate that. Thank you, Captain.
Thank you.
Okay, thank you, Captain. No further questions.
Can I ask just one question with this order?
Mhm.
In normal cases, when we get court orders, live ammunition is never returned. Is that fact with this case also, or no?
No, I mean, I don't have any information that there's any suspicion that this gun has been used in other crimes. I don't have any suspicion that the ammunition was illegally obtained or illegally possessed. There is no conviction standing that would prevent the return of Mr. Talley's property.
Okay, thank you. Just wanted to be clear.
Appreciate that.
Okay, thank you. Thank you. Yeah.
Anything further?
I think
all the issues are resolved one way or the other.
All right, thank you. It sounds like we have established that the department does have all of the property in their possession. Mr. Talley has a roadmap to follow to get that property back. Sounds like it shouldn't take very long. And then if you start it tomorrow, you might have it within, I would expect that you would have it within a week. At most, given. Now, the court's done a little bit of research on this too, and it seems that the only thing that should prevent the return of the property is the discovery that Mr. Talley is for some other reason prohibited from having a firearm. I don't have anything to indicate that.
It's the Constitution. Any evidence later discovered as a result of that unlawful conduct is generally considered inadmissible in court, according to Mr. White, because the officers lacked probable cause to make the original felony arrest. Every piece of evidence obtained afterward was legally tainted and should therefore be excluded from further proceedings. The defense further cited Michigan Criminal Jury Instruction 11-25A, which outlines the elements required to prove a firearm brandishing offense. To obtain a conviction, addition, prosecutors must establish that the defendant possessed or controlled a firearm in a public place and intentionally pointed, waved, or displayed it with the specific purpose of causing another person to fear immediate harm. Mr. White concluded by emphasizing Officer Stern's own testimony, noting that law enforcement never believed Mr. Talley intentionally threatened the officers with the firearm. If the required criminal intent was absent from the beginning, the defense argued, the prosecution lacked a lawful basis to establish probable cause for the original arrest. The defense argued that nothing in the evidence demonstrated Mr. Talley intentionally aimed or handled his firearm in a manner designed to intimidate or threaten law enforcement. Without proof of deliberate criminal intent, the statutory requirements outlined in the jury instructions could not be satisfied, leaving the original felony allegation without a lawful foundation for probable cause. After reviewing the testimony and, with the felony allegations no longer supported, the only issue left for the court to resolve was the civil infraction related to Mr. Talley's lawful possession of a firearm. The final witness called by the prosecution was Captain Heather Cameron, who oversees the property management unit of the Detroit Police Department. Her testimony focused on the department's custody of the evidence seized during the arrest. Judge Ramsey Heath then addressed the issue of Mr. Talley's personal property and indicated that, if no legal barrier existed, the items should be returned. Captain Cameron verified the department's inventory records, confirming that the seized property included a long rifle, a handgun, 2 firearm magazines, and Mr. Talley's valid concealed pistol license. After reviewing the evidence, Judge Heath found that Mr. Talley had no disqualifying criminal conviction or legal restriction preventing him from lawfully possessing firearms. Based on that finding, the court reaffirmed its earlier order requiring the Detroit Police Department to return all of his property. The judge further explained that the city had no lawful authority to continue holding any of the seized items, including the live ammunition. The hearing ultimately highlighted the importance of requiring law enforcement officers to comply with constitutional standards at every stage of an investigation. It also demonstrated that courts carefully examine whether every statutory element of a criminal offense has been properly established before allowing a prosecution to proceed. Throughout the hearing, Dennis White's cross-examination exposed several weaknesses in the prosecution's theory and emphasized that police actions must be judged according to the facts known at the time of the encounter, not by explanations developed after the arrest. The court reaffirmed that a lawful custodial arrest cannot be made unless officers possess probable cause to believe a specific criminal offense has actually been committed. Because neither responding officer testified that they believed Mr. Talley intentionally threatened anyone or created an immediate danger, the essential element of criminal intent required for a felonious assault charge was never established. Without a legally valid arrest, the state also lacked any lawful justification to retain Mr. Talley's firearms or other personal property under the guise of an ongoing investigation. In the end, the court ruled that the arrest was unsupported by probable cause, ordered the suppression of the evidence obtained as a result of that unlawful arrest under the exclusionary rule, and directed the immediate return of all property seized from Mr. Talley. If there is another courtroom case you'd like us to analyze, let us know in the comments below. Thanks for watching, and be sure to subscribe for more in-depth legal case breakdowns and courtroom analysis.